Hello, and welcome to Filing for a Civil Protection Order, part of the Protection Order Process Series brought to you by Oliver Law, LLC, a Colorado-based family law firm dedicated to expanding access to the legal system. My name is Justin Oliver, and I am the owner and founding partner of Oliver Law. And in today's segment, I will discuss and give sort of a general overview of the initial legal considerations parties must contend with when filing for a civil protection order in the state of Colorado. The following presentation is intended to convey general legal information only and should not be taken as legal advice. The conveyance of information provided in this segment is not intended to create an attorney-client relationship, and viewers should not act upon the information provided without first seeking professional legal counsel. Civil protection orders, abbreviated CPOs, are civil cases brought by individuals in county and district courts. And these protection orders should not be confused with other types of protection orders, like the mandatory protection order entered against defendants in domestic violence criminal cases, or the no contact orders that are often associated with bond or sentencing conditions. Now, many of the forms needed to complete the protection order process can be found online at the Colorado Courts website, which is on your screen there, www.courts.state.co.us/forms. And additional legal information can be obtained by reviewing the Colorado statutes listed on your screen. And, as always, if you have a disability and need a reasonable accommodation to access the courts, please contact your local ADA coordinator, and the contact information can be obtained on the Colorado Courts website on the administration's page. Protective orders are orders issued by a court telling one person to stay away from and not to hurt, threaten, or communicate with another person. These orders can go by several names, including protection orders, restraining orders, injunctions, and no contact orders. These orders are usually issued by a judge for the protection of family members exposed to domestic violence. They order an abuser to do or not to do certain things that the judge specifies, and can include some or all of the actions listed here on your screen. There are a number of reasons that parties decide to apply for and get a protective order. And I'd like to go over and discuss some of those reasons with you now. The first is that while some people who have restraining orders against them try to violate those orders, most people do not actually violate those orders. Also, a protective order gives the abuser a message from an objective authority figure that the abuse must stop. And at the same time, a protective order empowers the victim by having an objective authority figure validate the reality of his or her danger. Another reason that people apply for and get protective orders is that a protective order informs law enforcement that the victim is serious about stopping the abuse and keeping the abuser away. And the protective order also delivers consequences if the abuser continues his or her abusive behavior. Also, a protective order documents the victim's attempt to change the situation and distance themselves from the abuser. Another important reason that people apply for these protective orders is that a protective order allows the victim time to contact a lawyer, and it may make the justice system aware of the victim's situation and provide victims with a way to get some added help from law enforcement before violence happens. Also, if the victim calls law enforcement when someone has or is trying to violate the order, this will give the victim evidence to use in a legal case that they may have against the restrained person. And lastly, if the victim has a protective order against violates the order, the victim can call law enforcement possibly before the restrained person can cause more harm. A civil protection order is issued by a court after a victim petitions the court to have someone stay away from them. A civil protection order requires the victim to go to court at least 2 times. At the first hearing, the victim provides information about the harm the other person has caused him or her, and why he or she thinks the person will hurt them again. At the second hearing, the restrained person, also known as the respondent or the defendant, has an opportunity to appear and give reasons why he thinks the order should not be made permanent. If the order is made permanent, it is in effect forever, unless the court cancels the order. However, the parts of the order concerning children will end after 120 days. It is therefore necessary that the victim also files in district court for a separation, divorce, or custody so that he or she can get permanent custody and child support orders. Parties looking to secure a civil protection order should be made aware that a person doesn't need an attorney to file for these orders. And although they may choose to use one in order to better protect their rights, a person can get the standardized form needed for these protection orders directly from the courts or through the judicial website at www.courts.state.co.us. Also, a point worth noting is that there is a filing fee associated with these protection orders, and an additional fee to have the other person served. Now, these fees can be waived for low-income individuals, and also they can be waived if the protection order is being sought for a victim of domestic abuse, stalking, sexual assault, or unlawful sexual contact. Temporary and permanent civil protection orders that are intended to prevent domestic abuse, assaults, emotional abuse of elderly, and stalking may be issued at any municipal court, county court, district court, probate court, or juvenile court. But venue is only proper in counties where one of three things occur. The venue is proper in counties where the acts that are the subject of the complaint or the motion occurred, in counties where one of the two parties reside, or in counties where one of the parties is employed. I'd like to take just a moment to touch upon emergency protective orders. Now, there is a Colorado statute out there that requires county and district courts to make judicial officers available to issue emergency protective orders when the courts are normally closed. Now, these orders can be either written or verbal, but they are very temporary in nature, and they typically expire on the next business day unless they're continued by the courts. And really all they are a gap filler to allow petitioners time to seek out and obtain the regular civil protection orders and temporary protection orders. A quick note of caution regarding civil protection orders. Unfortunately, protective orders can sometimes have the opposite effect from which they are intended. If an extremely violent abusive partner or an abusive partner who has no respect for the law is served with a protection order, then he or she may seek revenge on his or her partner and place the victim, their children, coworkers, families, and friends in danger. So it's important to always have a safety plan and a backup plan in place for such situations. And this concludes this section of Oliver Law's protection order process. If you have any specific questions regarding your Colorado case, I encourage you to contact Oliver Law LLC. Also, don't forget to visit our website at oliverlawcolorado.com and like our Facebook page at facebook.com/Oliver Law Colorado. Until next time, my friends, this is Justin Oliver signing off for Oliver Law and the Protection Order Process series.